Hello, everyone, and welcome back to another episode of Level Up Law. This will be our first episode for 2021, so Happy New Year to all of you. We'll be continuing throughout 2021 to level up your legal knowledge on all the areas that we practice law in here at South Carolina Legal Services. I'm Susan Ingalls, Senior Staff Attorney and Consumer Law Unit Head, and today I will be actually presenting Rules of the Road on Auto Repossession Part 2. You'll recall that last week we had Part 1, in which Rick Fox provided a lot of information on kind of what the rules are when it comes to repossession. And today I'll be talking about some of the actual litigation aspects of that. We many times when we're reviewing recommend that you seek out the services of an attorney. So we'll be talking a little bit about what attorneys can do for you today when it comes to repossession lawsuits. I do want to remind you, of course, that the webcast is being recorded and it will be posted on our YouTube channel for South Carolina Legal Services later this week, and along with the slides that I'll be showing you in the presentation today. And remember, as always, this is not legal advice, just some general information, and especially when it comes to auto repossession and all the ins and outs of the procedure when it comes to lawsuits. There's so much that is there, and we're just really hitting the high spots today. So at the end of the presentation, I will provide you with the contact information for South Carolina Legal Services, so that if you have any issues on auto repossession and think you need a lawyer to assist you when it comes to a lawsuit in that regard, you can definitely give us a call and see if you're eligible for our free legal assistance. Today you'll be in listen-only mode, but if you have any questions, please feel free to put them in the question box shown on your screen. So let's get started. So today we'll be talking about auto repossession, Part 2, the lawsuits that are related to auto repossession, potential lawsuits not only for the creditor that might be suing you, but lawsuits that you might have back against that creditor or that dealer as well. So first I want to talk real quickly about what are the objectives of a lawsuit from the two different perspectives. For you, it might be getting your car back. It might be just avoiding a potential lawsuit down the road for a deficiency judgment once your car has been repossessed and sold. It might be to clear your credit report or to recover damages for violations of the laws that Rick talked about in Part 1 and other remedies that you have under our state and federal law. For the other side, for the creditor, they're going to either want to be collecting the money from you, or they want to just get a judgment against you for the amount that's owed. And then sometimes they're really, hotly pursuing the collection of that judgment. And sometimes that's that original creditor, and sometimes it's a creditor on down the line. So who are you dealing with when it comes to a lawsuit? Well, it might be a buy here, pay here dealership. It might be what we call a captive finance company, and this is a finance company that's kind of tied to a particular dealership. It could be a regional, just smaller finance company, but it could also be a traditional dealer that we think of in the large dealership sense and large banks and finance companies. But it can also be a debt buyer, because once a car is repossessed and sold, that deficiency amount that might be owed is a debt that the creditor can sell to a debt buyer. And so sometimes it's the debt buyer pursuing you, and we'll talk about all of these different players in this game as we go along. So we'll be mainly talking about the defenses that are available to you if you're sued. And there are a lot of them, more than you might expect. also the options when you have claims of your own. And, you know, without going into a law school class on civil procedure, the way it works is you may have a lawsuit of your own for violations of statutory law, both state and federal. You might be being sued by the creditor and have affirmative defenses that you can use as set off of any remaining balance from a repossession sale. And you, again, might have, just as you might have a lawsuit of your own, if you're being sued, those claims or causes of action can be used back against the creditor in what we call a counterclaim, and that can yield, just as in your own lawsuit, money damages or set off for you. Again, this presentation is mainly going to focus on repossession, defenses and claims under Article 9 of the Uniform Commercial Code, but it also will review some additional claims that you can make both as a defense or on your own in your own lawsuit. Now, the Uniform Commercial Code is contained in South Carolina Code Title 36, Article 9. And I do want to have you keep in mind that defenses and claims that you might have in a repossession situation will not only apply to the original seller or dealer of the car and the finance, but it will also be the finance company and a possible debt buyer. So as your debt for a car moves through a chain of owners, all of those are liable for whatever happened starting in the beginning, for the most part. So it's important to know that if you have claims against the dealer, those can be asserted in a lawsuit after a repossession, even if it's not the dealer that's suing you. And another thing, just at the outset, statutes of limitations. Now, this is, of course, a defense to a lawsuit, and on the particular, depends on the particular claim, but it is important to be aware of it when you have a potential repossession situation. You need to know what your rights are and how quickly you need to assert those rights. So, for example, the Uniform Commercial Code in South Carolina, the deficiency amount, you can be sued for that for up to 6 years. And so that's a pretty long time. And quite often, you might have a debt buyer who has bought the debt, and they wait till the very last minute to file that lawsuit. So it could be, 5 years and 10 months before they actually sue you. So you may not be out of the woods as quickly as you might think. Now, other claims that you might have back against the creditor can be anywhere from a year statute of limitations to 4 years statute of limitations. And so we can't go into all the details of every single type of cause of action. We'll just touch on a number of them as we go along. But it's important to know that at the outset that there are limits to the time in which you have to bring a claim. So if you have waited to bring a claim where the statute of limitations is, a year to 4 years, and you're now being sued for a deficiency at 5 years and 10 months, well, the statute of limitations has run on those other claims. However, they can be used as affirmative defenses at any time, even if their statute of limitations as a claim has expired. And so they can be used to offset what you might owe as a deficiency if that's awarded in the case against you. Typically, a statute of limitations in a case like this is going to run from the date of the breach of contract, but it can be from the last time you made a payment. Okay. In part one, Rick talked about all of the different requirements when you are in default and a creditor is repossessing your car. And I would refer you back to that episode for some of those details. But just suffice it to say that the main thing when it comes to repossessions under Article 9 is that everything has to be done in a commercially reasonable manner. And all of the rules and regulations about notices to you about the repossession and the sale of your car and what happens after that, it's all laid out in the statute, and it has to be followed. And if it's not, that's going to be a violation by the creditor and a claim for you. So first, let's talk about the notice of sale issues, because that's the first thing that happens is your car's been repossessed and you get that notice of sale. It's important to know where those minimum disclosures are located. And again, you can see Rules of the Road Part 1 for some of those details. But when it comes to a lawsuit, if those required disclosures, which I'm not going to review in detail here because we did that in Part 1, but if those required disclosures are missing, then the sale could be held commercially unreasonable as a matter of law. And so when you show that those disclosures are missing, then the burden of proof moves from you over to the creditor. You will also have statutory damages for that if you can show that it was commercially unreasonable because the disclosures were missing. And even if the time has expired on the statute of limitations, again, as I mentioned before, that can be a reduction in the amount that you owe as a deficiency. And your statutory damages in that regard are going to be whatever the finance charge was, plus 10% of the principal amount. The failure to comply with that code section is a fine of $500, as long as it's part of a pattern of non-compliance. Now, I think it's important to think about how you would begin this type of assertion in a lawsuit, because you're going to be, typically, if you're not filing your own lawsuit and you've been sued for a deficiency, these are the kind of things that you need to be thinking about. And you might be being sued for a deficiency 5 years after the fact. So it's important that you keep that in mind, and as you think about what your defenses are, and you don't have a whole lot of time to think about it once you've been sued, you have to respond in 30 days, but you need to think about all the options that you have when it comes to not only your defenses, but your claims back against whoever is suing you. Now, we talk a lot about deficiency. And just real quickly, the deficiency amount is an amount that is calculated after your car has been repossessed and it's been sold. And so the party who has repossessed and sold your car is required, we'll talk about this in a minute, but they're required to send you a disclosure of what they said was still owed, the amount, and minus the amount of money that they sold the car for, but adding back whatever the cost of that sale were. So when we talk about deficiency, that's what we're talking about. So as I mentioned with debt buyers, quite often a creditor doesn't want to mess with pursuing that deficiency amount, and so they'll sell it to a debt buyer, and then the debt buyer pursues you for that. But again, all of these defenses and counterclaims will apply on your behalf, even in that kind of a lawsuit. Okay, and so here is the post-repossession deficiency notice, which I really just was outlining the balance remaining after the sales price and expenses. Now, again, the remedy for that is a violation of that is $500 if it's a part of a pattern or consistent with some ongoing practice of noncompliance with this creditor. It's important to keep in mind also that under the UCC, you can request an accounting at any time, but you're entitled without charge to one free, basically, response to a request for an accounting of your loan. If you do that, it's to be provided within 14 days, and you're entitled to that without charge in any given 6-month period. They can't charge you for that, but they can charge you up to $25 if you ask for it repeatedly within the same period of time. But there's also a remedy for noncompliance with that, and that's also a $500 fine. And I just want to mention, as we're talking here about the notices that you're getting, it's important to keep them and to not write on them. They're possibly going to be evidence in your case, because if they're not adhering to the specific laws which Rick outlined in part 1 of our series on repossessions, then that's going to be a violation that you can sue that creditor for, or debt buyer, whoever is suing you at the time. But if you write all over it, that's going to be a problem from an evidentiary standpoint. And you might be writing notes to yourself that you wouldn't want a judge or jury to be seeing, or it might not even be allowed into evidence if it's been torn or written on and so forth. And that also applies to the envelopes, because typically that envelope is going to have a postmark date, and that can be important. It also would have the address that it was sent to. That's important as well. So just do this with all the communications. Once you start to struggle with a loan and you think you might be in danger of repossession, and you start getting that correspondence, definitely keep all of those. Don't just toss them or ignore them. The other thing I wanted to mention is sometimes a creditor will say that you've waived that notice, and so they're not required to give you the notice. But that's not the case when it comes to the notice that you're supposed to get. If you have waived that notice, it has to be something that was signed by you after you got behind, after you defaulted on your loan. And I also wanted to mention here that sometimes they might try to say that you've waived notice because you turned your car back in, what we call a voluntary repossession. And that is not a waiver. You are still entitled to all the notices that come along with the repossession of a car and the subsequent sale. Okay, so let's start talking about Article 9 and the defenses that you have under Article 9. And again, these may also be claims that you could have in your own lawsuit or in a counterclaim when you get sued. If notice is not provided properly, if there's a breach of the peace, or there's this commercial unreasonableness factor that's involved, then you can claim any of that against the creditor as a bar or set off to a judgment for a deficiency. And these are just some options that you might have as violations of some of those notice provisions. The notice is not sent at all. It's not sent to the right address. Wrong type of sale. They say it's going to be public, but it turns out they do it as a private sale. Maybe they give you the wrong date, time, or place in the notice. So any number of those can violate that notice provision and be a claim for you. Now, one point on the address. Keep in mind, if you've moved since you entered into this financial arrangement for the purchase of a car or a loan on a car, you've got to keep the lender informed of your address. It's no defense to say, oh, you didn't send it to my current address if you haven't informed them of your new address. So keep in mind, if you move, you want to notify them of your current address and do it in such a way that you can prove that you did it in a lawsuit later on. So, for example, a certified letter with a return receipt green card is really the best way. Okay, another defense, a commercially unreasonable sale. So there's different ways to show that a sale is commercially unreasonable, but these are just a couple of examples. For example, if the seller or creditor who repossessed the car is selling it for an artificially low price in some sort of self-dealing type of situation, so they're selling it to a known party for a lesser amount than what it's really worth, and you can prove what it's worth through the NADA manual that gives the fair market value of cars. Also, an unreasonable delay before the sale. You know, they can't repossess your car and then just sit on it for a long time because you might want to redeem it, and you need to get notice of all that, and in a timely fashion. Okay, breach of the peace. We talked a lot about this in Auto Repo Part 1, and so I refer you to that for any other particulars, but just keep in mind that it can be a defense and a claim where you can reduce the amount that's owed, or maybe even get your car back if some of these type of things have occurred during the repossession. Violence or threats, having an argument in the public, a repo over a, obviously strenuous objection, not just you standing there saying, oh, I don't want you to repossess my car. And Rick talked about that in great detail, I think, in Part 1, as well as they can't come onto your property in a way that is something like opening a garage, breaking down a fence, or anything like that, because that's, in some ways, it's like trespass, really. So when there's been a breach of the peace, and one thing that comes to mind, because repossession agents can do a lot of things in the repossession process, but one thing that I've seen quite often is sort of a misrepresentation of who they are. So sometimes a repossession agent that is sent by the creditor to get your car may have a tow truck that has a seal on it that looks like it's some sort of official law enforcement seal, and they represent themselves as coming from some form of law enforcement. So there can be any number of things that a repossession agent does or fails to do that can be helpful to you in your lawsuit. So that's always something to keep in mind. And again, I talked about evidence before with the notices and the envelopes. If you are subjected to a repossession, you want to write down some, simultaneous notes about what happened so that you won't forget, because it could be a long time before you're testifying about it. Okay, these are just some more defenses that you may have that don't necessarily have anything to do with the UCC, which is a statutory scheme. But we have just a good little laundry list here, and maybe some more later on. There are some other common law defenses and claims. But there's any number of things like the way that they have dealt with you hasn't been proper in some sort of way. Another thing is you may be up to date, you may be current, you may have entered into an arrangement by which you paid something less than what you owed, but the creditor said they were accepting that. And so that's the kind of thing that you've got to assert, as soon as possible. You can do that as a defense in a deficiency lawsuit. Also, again, keep in mind that if they're not available as a counterclaim because of the statute of limitations, you can still use them as a defense in a lawsuit for that deficiency. Okay. So again, some affirmative claims, which is really what we have been talking about here. Just to recap, failure to send proper notice, breach of the peace, commercially unreasonable disposition meaning sale basically, can be that affirmative claim for damages beyond just being a defense. And so here's a couple of other examples. We already talked about breach of the peace. If you had some damage from that, maybe there was damage to your property, damage to a fence or a garage or something of that nature, then those are damages that you can sue the creditor for. Also, if your car was sold for more than what you owed on it, you're entitled to that surplus and notice of what that amount is. And if that's not properly provided, that's a violation of the statute. That can also be an affirmative claim. Okay, just to recap on the repo agent, keep in mind that the creditor is liable for the acts of their agent that they send to repossess your car. They may try to say, oh, well, they're just an independent contractor. We're paying them. We're not responsible for what they do. But the duty to do the repossession properly is what we call a non-delegable duty. So they can't delegate the duty of doing it properly under the law to somebody else just because they're paying them separately and they're not like an employee of that company. So that's really important to remember, that what that repo agent does, the creditor is responsible for. Okay, I just mentioned the surplus, or also there's possibility of a remaining deficiency. And that's usually what we see, is that there's still an amount owed after the sale and the addition of the costs. But the creditor has to send you an explanation of that, right? And you have the right to demand that and demand that it be correct. This is separate from the accounting that I mentioned earlier, but it applies specifically to the post-sale notice of what price they got, what expenses there were. And there's different situations when this is due and how long they have to give it to you and so forth. So I'd refer you to the statute for that. That's a little too much detail to go in today. Just suffice it to say that you're entitled to a detailed accounting of what happened in that sale and what the result is for you as the debtor. And again, as with all notices, if this is incorrect and you call them on it and can prove that, then that's also a defense and possibly a claim against them in addition to being a defense. Okay, now here are some other possible claims. And when we call them affirmative claims, that means that there's something that the creditor or their agents or their predecessors in interest, we call them, maybe like the dealership or something like that, something they did or didn't do that gives you the right to remedy or damages from them. Now, in South Carolina, we have the Dealers and Distributors Act. This is a great resource for you because it basically prevents a dealer from unfair or deceptive acts in the transaction with you that happened originally. And this follows throughout, but again, it does have a statute of limitations. It does include prohibiting the dealer from taking action that's arbitrary, in bad faith, or unconscionable, and that causes damage to any of the parties to the lawsuit, including you, or to the public. So this is a great statute. It does provide for attorney's fees and costs if you are successful. And also, one of the things I like about it is it defines fraud a little bit differently than we normally have. Fraud is a very hard thing to prove, either as a defense or as a claim against the person that is suing you. And so they have a little bit of a different definition of fraud that's not quite as strict. And I have it here It includes a misrepresentation in any manner, whether intentionally false or due to gross negligence of a material fact, a promise or a representation not made honestly and in good faith, and an intentional failure to disclose a material fact. So this happens a lot in these car purchase situations, especially with some of the non-traditional dealerships that we mentioned at the beginning. And so I think it's really important to remember that this act does provide some great relief for you, not only as a defense to a lawsuit for a deficiency, but also as a claim of your own against the dealership or the subsequent creditors of the financing. Okay, here are just some violations to watch for from the Fair Debt Collection Practices Act, because again, that's another option for a lawsuit. They might, obviously have misrepresentations in their communication with you. Some of those are going to be violations under Article 9, as we've already discussed in great detail. But it could also be phone calls to you misrepresenting things, sending sworn statements or other things that are, not properly representing what the situation is. They might sue you in a jurisdiction other than where you live or signed a contract, and they're not supposed to do that. They might be suing you for amount that's not actually due. It's not all that rare for us to see folks who actually are current on their loan, or maybe the accounting has gotten mixed up, or they've been charged along the way for something that they shouldn't have been charged for, and you have to sometimes battle that out. And finally, I think a good example of the FDCPA violations can be suing when the statute of limitations has expired, and that surprisingly does happen. Okay. We also have the South Carolina Unfair Trade Practices Act, which governs unfair or deceptive acts that are not just applicable to you as an individual in your particular situation, but are representative of what this creditor might do to everybody that they are dealing with. And that's what this act wants to protect. Not just something that happened to you alone, but something that happened to you that clearly is or could happen, is happening or could happen to other people that are in the same position as you. The violations that we've talked about on the Fair Debt Collection Practices Act and the Dealers and Distributors Act can also fit under this, because it's those actions or that inaction that was done can also, if it's possible that it can happen to others besides you, then those can be part of this claim as well. Some examples: misrepresentation about the vehicle or the terms of the purchase or financing prior to the sale, failure to disclose when they have a duty to disclose. Things like, has this car been wrecked? There's lots of cases out there, including in South Carolina, about cars being sold and the buyer being told the car's never been wrecked, and then it turns out it's clearly been wrecked. We also see odometer fraud, and that's got its own federal statute for odometer fraud. That's a separate one that we don't even mention here. There's just so many. We're trying to hit the high spots. And then, of course, failure to comply with the UCC, as we've described here, and which is really the focus of this presentation. That can also be an Unfair Trade Practices Act violation if it's something that clearly is happening or could happen to someone in addition to you in the public here in South Carolina. You might sometimes hear it referred to in other states as the UDAP statute. which is unfair and deceptive acts and practices. So the same type of thing, just with a different name in other states. So if you see laws referring to UDAP statutes, this is what ours is called here in South Carolina. Truth in Lending Act. This is one that's got that short statute of limitations of 1 year, so keep that in mind. If they've not properly disclosed interest rate and the financial part of the deal when you first buy a car, that's important to know and to sue on within that first year. Now, if the year's gone by and you're not being sued in regard to this financing until after a year, you can still use this kind of violation as a set off and a defense to a lawsuit against you for a deficiency. And also, as with many of these statutes, just to note that there are statutory damages and attorney's fees and costs to whoever prevails on it. And with all of these, you need to keep in mind, you know, if the other side prevails, you may be responsible to them. Telephone Consumer Protection Act. This is, although it's been around a while, it's still kind of new when it comes to folks using it in lawsuits and as defenses, but it does protect you from essentially automatic repeated dialing where they're using a machine to call you. You have the right to not be subjected to that. It has to be without your consent, and you need to keep in mind that most paperwork that you sign when it comes to financing probably has somewhere in it that you're giving your consent to this kind of calling. So you have to revoke that consent and then have this happen to you after you've revoked consent. You may not have given consent, but typically most paperwork has that in there. And this is why we always say it's important to read the paperwork before you sign, read those terms and conditions. Don't get in a hurry. These are some other common law, we call them, claims. Negligence, negligent misrepresentation, fraud, and fraudulent misrepresentation. So this is just when the dealer or the creditor has a duty to disclose something to you or to handle your account properly or do things in a certain way, and then they don't do it, they're negligent about that, then you may have a common law claim against them, as well as as an affirmative defense to a lawsuit back against you. So, you know, fraud, again, it's hard to prove, but in the Dealers and Distributors Act, it's a little bit easier, so keep that in mind. Declaratory judgment action. This is one that we don't do a lot of or see a lot of, but you do have the right to have a court declare that you are paid in full, that you don't owe the creditor any money. And that's just something to think about, you know, when you're making your decision about how you want to pursue things. You know, if you've got a car that you had problems with and the dealer misrepresented about and so forth, you know, you may not want to keep it. You may not, you know, that may not be part of your decision making. Just keep in mind declaratory judgments are out there as a possibility, but we don't see that done, you know, very much. Sometimes it's really just essentially done within the other type of lawsuit. You know, there's a finding that you've paid everything and you're not in default. So that's usually how that determination is made in a lawsuit, not through a declaratory judgment action. Now, sometimes you can consider getting an injunction or a restraining order to restrain the repossession. You know they're trying to repossess your car, and either you feel like they don't have the right to, or there's some other considerations that need to be made before they just come and do what we call the self-help repossession. And Rick talked about that in part one of auto repossession. You know, self-help repossession is just when they come and tows your car away from in front of your house. Anyway, there is the possibility of getting some sort of restraining order before that has happened, but you have to verify that, and of course show that there's going to be immediate and irreparable harm, and you're basically having to prove that you don't owe any money, and there's a lot to that really this kind of an action isn't necessarily created for. And the other thing is that you have to post a bond, and because if you're wrong, and then you do owe the money, and they do have the right to repossess, and they may have a loss, and as a result, and that bond is there to make good on that loss. However, you may be right, and if it's worth it to you and you're able to get a bond to post, and the car's that valuable, and your case is that strong, you might want to go this route. Keep in mind that the prevailing party in a case like this is going to be entitled to costs and attorney's fees, so you definitely want to be really sure about this kind of claim if you're going to make this kind of lawsuit. One last note is about bankruptcy. Now that's kind of a whole nother area of law, and you don't want to always file bankruptcy just because of a car situation. There's a lot of other things that apply in bankruptcy. You have to submit all your debts and all your assets to the bankruptcy court, so you can't just file bankruptcy only on the car. But if bankruptcy is something that is really something that you need to do anyway because of other debts or whatever, then you can file bankruptcy, and as part of that, set up a repayment plan for that car. But you got to keep in mind, if it's a fairly new car, if it's been within the last 930 days that you bought it and financed it, then you are going to have to continue making the regular payment. You don't get that ability to spread the payment out over time in a smaller monthly amount if it's a newer financing and purchase arrangement. Sometimes in bankruptcy, you can get your car returned if it's already been repossessed, but it has to be within a certain short amount of time. So that's always a consideration. And in some cases, it's the right one. But as with all of these issues, you definitely need to get the advice of an attorney, because there may be, when it comes to bankruptcy, something about your situation that makes bankruptcy not a good idea for other reasons. And really, it's only an attorney that can review that with you and make sure that you're doing the right thing for you. So that is all that I have for today. Hopefully that's sort of a good overview for you on some of the things that are out there, some of the rights that you have to defenses and claims when it comes to repossession. It's not the end of the world if your car has been repossessed, and you do have rights. And so I want to close with giving you the contact information that we have here, so you can call us at South Carolina Legal Services and apply for our assistance with this and other types of cases that we handle. You can call. Our intake folks are always standing by Monday through Thursday from 9 to 6. If it's easier for you, you can apply online at lawhelp.org/SC. And we also, we always like to remind you that we do have a lot of great resources on this and other topics on that same website, lawhelp.org/SC. So please go there and check those out. And also keep in mind that we'll be continuing to do our Level Up Law episodes throughout 2021. And we invite you to keep watching, and whether live or watching the recordings. And, subscribe to our YouTube channel and ring that little bell so you'll get those alerts anytime we're posting a new episode, or other videos that we do that are unrelated to Level Up Law. And this is a series of free legal webcasts that we do every Tuesday at noon. And we really appreciate it when you come and watch us and ask your questions. But also you can make comments when the videos are posted and let us know if it's helpful to you or if there's another subject that you'd like us to do an episode on. So be sure if you need legal assistance to contact us and see if you're eligible for our free legal services. And I want to remind you to tune in next Tuesday at noon when our subject will be solar panels, a quick guide and review on solar panels and solar energy. This is a big topic nowadays, and it's there's so much information on it that we're doing another two-parter like we did on auto repossession. So next week will be just a quick overview of solar panels and solar energy, and then later on in February we'll have part 2, which will talk about some of the scams and things to watch for when you're signing a contract for some sort of solar energy to be provided to your home. Well, that is all for today. We thank you for tuning in to Level Up Law, where we're bringing all this hopefully helpful information to you, and we hope that you will give us feedback. We look forward to having you back with us next week. That concludes today's webinar. Thanks for watching.